Hello, everyone. Welcome to my webinar. My name is Mar Harris, and I am a staff attorney at Tzedek Legal Services, specifically in the Small Business Development Program. And today we will discuss the Corporate Transparency Act. As a small business owner, this will directly affect you. This law represents a significant step toward enhancing accountability in the corporate world with growing concerns about corporate practices and their impact on society. The CTA acts as a watchdog, essentially, for FinCEN, which is the Financial Crimes Enforcement Network branch of the Treasury Department. And understanding the CTA is crucial for all small business owners, as again, if you make $5 million or less, and have 20 or less employees, you will have to report to FinCEN. And by adhering to the CTA, you can, or complying with it rather, you can save yourself potentially large fines that rack up per day, and you can save yourself from potential prison time. So together, let's explore the implications of the Corporate Transparency Act and how it can shape the future of small businesses and corporate responsibility. So at Tzedek Legal Services, we believe everyone deserves access to justice regardless of your background. Since 1974, our nonprofit organization has proudly provided free, high-quality legal services to the diverse residents of Los Angeles County. And our mission is straightforward. We aim to empower all individuals, regardless of race, religion, ethnicity, or immigration status, by helping them navigate the legal landscape with confidence. We understand that legal compliance can be complex and overwhelming, but we are here to assist you, small business owners, every step of the way. For entrepreneurs, especially those from low to moderate income backgrounds, our small business development program offers invaluable support. We are committed to helping you address essential business law matters crucial for your small business's success and sustainability in today's competitive market. Our small business development program is a comprehensive initiative designed to offer extensive support to entrepreneurs in key areas. The program aims to help form business entities, ensuring that new businesses are structured correctly. We focus on drafting and negotiating contracts for our clients, facilitating commercial leases, protecting intellectual property through registration and enforcement, navigating employment law issues, and managing insurance matters. We provide these services through a combination of small business legal academies, informative community presentations, detailed guides, and direct client representation, enabling us to meet various needs effectively. So again, these are the areas of law in which we assist small business owners and how we assist them, which, as I mentioned, through direct client representation, guides and other resources, small business legal academies, and community presentations. Clients may qualify for our pro bono direct representation services by meeting certain household income levels, which are assessed annually. We also evaluate the business's profits and sales figures to determine eligibility. Our legal services are specifically designed for for-profit businesses in Los Angeles County, helping local entrepreneurs navigate the legal landscape effectively. And if you have any questions about your eligibility, please feel free to reach out to our team for further assistance. And here you can find links to free services. And if you have questions, please feel free to reach out to me. And also included on this page is our application for assistance, which you can find at betzedek.org in the Small Business Development. In today's webinar, we will discuss the current status of the Corporate Transparency Act, what is a reporting company, who is a beneficial owner, who is a corporate filer, what are acceptable forms of identification, when does reporting begin for the small business, where do business owners file, what are the penalties for non-compliance with the CTA, and we will also discuss who will have access to your information. Basically, the Corporate Transparency Act is a piece of federal bipartisan law that requires millions. It will be millions of small business owners to report info on their beneficial owners to the Financial Crimes Enforcement Network, or FinCEN. And the idea behind this law is to further the National Defense Authorization Act, and it's to combat illicit activities such as money laundering, tax fraud, drug trafficking, and the financing of terrorism. So any business, domestic or foreign, that are registered to do business in anywhere in the United States must report to FinCEN, and they must report yearly. Any corporation, LLC, partnership, general partnership, limited liability partnership, business trust, or any other domestic or foreign entity that is formed or registered under the laws of the United States or any state or tribe and has at least one beneficial owner, again, must report to FinCEN or face penalties and fines. So currently, the U.S. District Court for the Eastern District of Texas has recently lifted the nationwide injunction that temporarily halted the implementation of the Corporate Transparency Act. As a result, the reporting requirements for beneficial ownership information are now enforceable, and companies must prepare for compliance. Although companies will not be fined currently, you still must report. And initially, businesses were required to submit their initial reports by February 19, 2025. However, due to ongoing discussions and legislative developments, this deadline has been extended to March 21st, 2025. This 30-day extension allows businesses additional time to gather the necessary information and to ensure accurate reporting. The best practice, however, is to report as soon as possible. Even though you won't be fined, you don't want to take the chance of potentially not complying with this new law. So in light of recent legal changes, companies that were members of the National Small Business Association, or the NSBA, before March 1st, 2024 are now exempt from the requirement to file beneficial owner information reports. This exemption is designed to alleviate the compliance burden on certain small businesses. However, only businesses that are part of the NSBA, again, are exempted from compliance. The Corporate Transparency Act, the landscape of this act continues to evolve with new legislative initiatives. The House of Representatives recently unanimously approved a bill to delay the BOI reporting requirement until January 1st, 2026. And although the Senate has yet to vote on this legislation, it indicates a growing recognition of the need for more time to implement compliance measures effectively. Additionally, Senator Tim Scott has introduced a companion bill in the Senate showing bipartisan support for this delay. Furthermore, the Financial Crimes Enforcement Network, or FinCEN, will revise the BOI reporting rules as well. The goal is to create a regulatory environment that minimizes the burden on lower risk entities, including many small businesses. These revisions may include simplified reporting processes or extended deadlines, making compliance more manageable for small businesses. So there are new deadlines for companies to comply with the CTA requirements of reporting to FinCEN. So, and it goes by the date that the company was created. Reporting companies that were created or registered prior to January 1st of 2024 initially had until January 13th, 2025 to file their beneficial ownership information reports with FinCEN. However, this deadline has been extended, as well as reporting companies created or registered in the United States on or after September 4th, 2024. That timeline has been extended as well. And reporting companies created or registered in the United States on or after December 3rd, 2024, and on or before December 23rd, 2024. That timeline has been extended as well. So what happens if a reporting company does not report beneficial ownership information to update or correct the information within the required time frame? You could face a fine of $500 per day for noncompliance, or up to 10 years in prison. And every time information changes about the beneficial owner, you must update with FinCEN, or again, face fines. So if the beneficial owner changes addresses, then you need to update that information. It's very, very important. You want to comply with these deadlines and these rules so as to not be fined. The Corporate Transparency Act is a federal law that went into effect on January 1st of last year, 2024, and it's part of the National Defense Authorization Act, and it's enforced through the Financial Crimes Enforcement Network, or FinCEN, which is a bureau of the U.S. Department of Treasury. And it's meant to establish a national registry of beneficial ownership information for the beneficial owners of almost all entities created or registered to do business in the United States. And as we mentioned before, businesses that have less than 20 employees and brings in less than $5 million a year. So many of the larger businesses will not be affected by this. The CTA also creates an obligation for many companies created or registered in the United States to report information about their companies, their beneficial owners, and company applicants. Sole proprietors conducting business in the United States are not required to report information about their business to FinCEN under this act. Under the CTA, a reporting company is defined as any corporation, limited liability company, or similar entity that is formed or registered to conduct business in the United States. This registration of the business is done either by filing a document with the Secretary of State or another relevant authority, according to the laws of any state or Native American tribe in the U.S. The CTA requires these reporting companies to disclose beneficial ownership information to the Financial Crimes Enforcement Network. This requirement applies to domestic reporting companies, which are entities established within the U.S., and foreign reporting companies, which are entities registered to operate in the U.S. And most companies will be a reporting company under the Act unless the entity qualifies for one of the 23 exemptions outlined by FinCEN. And you can find more information about the exemptions on fincen.gov. So what does a reporting company have to report under the Corporate Transparency Act? Most entities created or registered in the United States must report information about the company, their beneficial owners, and their company applicants. Required information for the reporting company includes the legal name of the company, any trade name used by the company, any DBA used by the company, the legal address, or the main site or U.S. operational location for foreign-based companies, the taxpayer identification number, and where the entity was formed. Information required for the beneficial owner information and the company applicant includes the legal name of the beneficial owner or the company applicant, the date of birth, the complete address of the beneficial owner or the company applicant, and either a U.S. passport, state driver's license, identification document issued by a state, locale government, a foreign passport, or a tribal ID. And you please note that when you submit this information online to FinCEN, it must be a photo ID. Additionally, any updates to the initial filing with FinCEN may be required in instances where a beneficial owner changes any of the required information, or in instances where a company makes changes to the operations or management of the business. Please note, businesses created or registered prior to January 1st, 2024 do not have to report company applicants. So, who is a beneficial owner according to the CTA? A beneficial owner is any individual that directly or indirectly has a significant ownership stake in the company, which is 25% or more, or the individual manages the company. So they have the individual has major influence on the reporting company's decisions or operations. The individual owns 25% of the company, or the individual has a similar level of control over the company's equity. A key to determining who has a significant ownership stake in your company is to evaluate how individuals in an entity exercise substantial control through contracts, arrangements, understandings, relationships, or otherwise. So please refer to the beneficial ownership guide on FinCEN for further details, and also please consult with an attorney or reach out to our department via our applications, and if you're eligible, we will assist you with this information, or if you're not eligible, we will direct you to the resources needed to find this information. Next, we will discuss who is a company applicant. So there are two types of company applicants. There's the direct filer, which is the individual who filed the creation documents for the company with the state or other authorized authority, or the individual that directs or controls the filing action, i.e., an individual who did not file the creation or registration documents, but is primarily responsible for directing or controlling the filing of the creation or the first registration documents. And you must note that companies or legal entities cannot be a company applicant. It must be a natural person. Which forms of identification are acceptable per the CTA? You may use a U.S. passport, a driver's license, a state or tribal issued driver's license, and ID cards. You may also use a foreign passport. We understand in today's climate there is a lot of anxiety about reporting information to the federal government, especially for undocumented immigrants. Therefore, the requirements of the CTA with reporting beneficial ownership information to FinCEN is concerning to many. However, understanding that the identification requirement and all the options available to maintain compliance with FinCEN is important. As a reminder, FinCEN is looking for full and accurate information and not necessarily focusing on the form of the identification one chooses to report with. In California, undocumented residents can own and operate corporations and LLCs under current state and federal law, and California does not restrict ownership of a business based on immigration status and does not ask for immigration status when registering. As of now, the CTA does not have a real ID requirement, and we don't know if FinCEN can distinguish between state IDs with or without a social security number, so please take note of that. Currently, undocumented business owners can obtain an AB 60 driver's license, and by 2027, an AB 1766 state ID. FinCEN, as mentioned before, does not currently require registration with a real ID, which requires a birth certificate and other biometric data to be submitted to the DMV. And using a foreign passport should be the last resort, and we recommend consulting with an immigration attorney to explore your options before doing so. So the deadline for reporting has been moved a few times based on court action. So to be on the safe side, I would recommend adhering to the original timeline and reporting as soon as possible, even though you will not be fined if you are late with reporting. It's better to just go onto the FinCEN website and report as soon as you're able to and as soon as you have the information, the required information available. It takes about 10 minutes to report online. It's a pretty quick and easy process. You can either file directly online or download the PDF version of the reporting document and then save it and upload it later. So you have two options for reporting, a PDF, or you can report directly on the website and submit the information instantaneously. So where do you file your beneficial ownership information and company applicant information? You will file this online at the FinCEN website or boiefiling.fincen.gov. And as I mentioned in the previous slide, you can directly upload the information on their website, or you can download a PDF and save it on your computer, go back to it when you need to, and then file it later by uploading it to the website. So you have two options for reporting. So what happens if a company does not file or reports fraudulent information to FinCEN? Well, as you can see, you have 90 days to correct the mistake, omission, or fraudulent information. Otherwise, you may face civil penalties of up to $500 per day that the violation continues, or criminal penalties, which could be imprisonment for up to 2 years and or a fine of $10,000. So these apply to whoever filed the BOI report or whoever provided the false information and senior officers at the time. So it's very important to make sure that you provide complete and accurate information to FinCEN to avoid these potential fines and penalties for your small business. Next, we will discuss who has the ability to see the information that you filed with FinCEN online. So who can access the information collected by FinCEN? FinCEN will give access to federal, state, local, and tribal officials. FinCEN will also give access to certain foreign officials who submit a request to the U.S. government. Under the CTA, such access would only be granted for matters concerning national security, intelligence, and law enforcement. Financial institutions and their regulators will also have access with the consent of the reporting company. So more information on the access rule. FinCEN may disclose beneficial ownership information to federal agencies if the requested beneficial ownership information is for use in furtherance of activity such as national security, as previously mentioned, intelligence, or law enforcement. Law enforcement activity includes both criminal investigations and actions and civil investigations and actions, such as actions to impose civil penalties, civil forfeiture actions, and civil enforcement through administrative proceedings. Prior to requesting beneficial ownership information, as the FinCEN agent, as FinCEN has established standards and procedures to protect the security and confidentiality of the information that is reported to them, the federal agency must certify that the agency is engaged in a national security, intelligence, or law enforcement activity, and that the information requested is for use in furtherance of that activity. And further, they will be required to provide the specific reasons why the requested information is relevant to said activity. Here are some additional concerns to consider with the CTA reporting. This information reported to FinCEN could potentially end up in the hands of ICE via a warrant. So if ICE is investigating a person or business and they lawfully obtain a warrant and serve that onto FinCEN, and the FinCEN determines that the warrant is valid, they will provide the requested information to ICE. And another concerning policy is that FinCEN has warning flags initiated within the reporting process. So if you have a non-federal ID, an unmatching address, or if you are confirmed to be undocumented, FinCEN will send this information to ICE, and ICE could later use it during removal hearings for undocumented persons and business owners. So again, it's very important that you correctly and fully input this information and speak to an immigration attorney when necessary. If you have additional questions about the CTA, please do not hesitate to reach out to our department by filling out an application and or sending us an email, as we can direct you to the appropriate resources if you need assistance with the CTA. And please note that it's an evolving landscape, and it's important to keep abreast of the news as it's continuously changing, and you want to make sure that you're in compliance with this federal law. So we recommend that if you are required to report, that you do so as soon as possible to avoid potentially getting fined or penalized later. So thank you so much for viewing this webinar, and I hope I was able to provide you with excellent information. Please enjoy the rest of your day, morning, evening, and take good care of yourself.